Welcome to Arth IAS. Dear aspirants, whenever you study Article 21 of Indian Constitution, you read one of the key concepts that is known as procedure established by law. Simultaneously, you also study about due process of law. And the Article 21 of Indian Constitution explicitly mentions procedure established by law and does not mention due process of law. In spite of that, we have to understand both these concepts in broader sense. Right, though there are minute differences, but you have to understand both these concepts in broader sense, and this concept is important for your from your prelims perspective as well as your mains perspective, even from your interviews perspective, right? So let's see what are we going to discuss in this video. So first we will discuss the historical and comparative foundations. So here we will discuss two constitutions, British Constitution as well as American Constitution, US Constitution, right? Then we will also see other constitutional models. So other constitutional models means we will also see the Irish Constitution, German Constitution, the Japanese Constitution, the Constitution of USSR, etc. Then we will see the reason or logic. What was the reason, logic, right, behind the adoption of procedure established by law over due process of law in India? Means why the constitutional fathers of India adopted due procedure established by law over due process of law. What was the logic? Then we will see the evolution of due process of law in India. As I said, that Article 21 explicitly mentions procedure established by law, not due process of law. But over the period of time, due process of law has evolved in India through different judgments of Supreme Court. Right? Procedure established by law is in letters, but due process of law is in spirit, right? Then we will see the comparison between due process of law and procedure established by law. What are the key differences between both the concepts? Then lastly, we will conclude with the similarities between both due process of law and procedure established by law. So let's dive in. First, so here we will start with the historical and comparative foundation. So first we will see the England, right, the British Constitution. So here you have to understand that rule of law and law of land, two words, two phrases, right? So Magna Carta 1215, you must be knowing that about Magna Carta, right? And it was issued by whom? King Jones, right? Which year? 1250. And mostly for the first time, certain rights were provided to individuals under this Magna Carta, right? So it held that no man shall be taken or imprisoned, decised or outlawed or exiled or in any way destroyed save by the lawful judgment of his peers or by the law of land. So here law of land means what? Law passed by parliament. You have to understand that in England law of land means law passed by the parliament. So without passing a law, no man can be taken or imprisoned, right? No man can be arrested, decised, outlawed or exiled, right? Throwing some person out of the territory, right? Or in any way destroyed. Any way destroyed means you are taking his life or liberty. So this is not allowed until and unless there is a law of land. And this concept later transformed into the idea of due process of law. Clear? Now, this demand was reiterated in the Petition of Rights 1628. This was another statute. And again, this demand was repeated. Simple. And since then, the observance of this principle has set what is known as rule of law in England. So, rule of law generally in any democratic country where there is written or unwritten constitution, there should be rule of law, right? For example, in India, there is rule of law, right? Not rule of state or rule by political leaders or rule by executive. There is rule of law. And what is the law? The fundamental law of land, that is constitution. For example, in India, when we say that there is rule of law, means there is rule of the fundamental law of land, that is constitution. Constitution is supreme. Simple. And as I said, law of land means what? Any law that is passed by the parliament in Britain. Simple. Next. So here you have to understand, though these two right, Magna Carta, and second statute, petition of rights, right? But both did not include the word or the phrase due process of law explicitly. But the important statute you have to remember, that is liberty of subject 1354, right? And under this statute, section 3, right, it explicitly mentions the phrase due process of law. So section 3 of liberty of subject 1354, right, that came in second half of 14th century, 1354, right? And section 3 of liberty of subject 1354 says that none shall be condemned without due process of law. So you can see the actual origin of this phrase due process of law lies in this statute, that is liberty of subject 1354. And from here, the American Constitution, the US Constitution, right, the American Constitution appear to have borrowed the phrase from there, right? And if you, we will discuss US Constitution. So in US Constitution, right, the 5th Amendment and 14th Amendment, 5th Amendment, right, and 14th Amendment mentions explicitly this phrase due process of law. We will see later. So now you should have conceptual clarity that the actual origin of the concept of or the phrase of due process of law is England. Which statute? Liberty of subject 1354. Under which section? Section 3. Right, be very specific, very accurate, right? Now US Constitution. So already, as I said, the 5th Amendment, which year? 1791. And we have seen the previous statute of England, what? Liberty of subject 1354. It means second half of 14th century, right? But, and we have seen that US borrowed the concept of due process of law from England, of that statute, liberty of subject 1354. And 5th Amendment, which year? 1791. It means second half of 18th century, right? It mentions that no person shall be deprived of his life, liberty, or property without due process of law. Explicitly mentions the word or the phrase due process of law. Simple. Again, 14th Amendment, which year? 1866, Article 1. Again, it also uses the word or the phrase due process of law. It says, no state shall make or enforce any law which shall deprive any person of his life or liberty or property without due process of law. So simply you can see 5th Amendment and 14th Amendment uses the phrase due process of law. And commonly, these two phrases are known as due process clauses. Simple, right? Now, already I have told you that what is the meaning of due and what is the meaning of process. Due means what? That is fair, just, impartial, right? Transparent. Process means law making procedure. Simple. So, if the legislature is making any law, it should be fair, just, transparent, impartial, and again the procedure. Simple. Now you have to understand that American Constitution, though it mentions the phrase explicitly, in spite of that, the American Constitution does not define the phrase due process of law. Simple. It depends upon the judiciary, and that's why, as it is not defined in the American Constitution, it gives the judiciary what? A wide area. And that's why, taking advantage of this, right, judiciary is giving much liberal or has given much liberal interpretation of the concept of due process of law according to the facts of cases. Simple, right? Now, one more important thing you have to understand, that while in England, right, all the parliament enacts is called law of land, right? Whether it is fair or unfair, right? As I said, that in Britain, the parliament is sovereign. It can do anything. It can make any law, right? So all or any kind of law that is passed by the Parliament of England, it is considered as law of land. Already I have told you The word law of land means what? Law passed by the Parliament of England. Simple. Again, right? But in the USA, a law is not a law unless it is in conformity with due process. Right? So the basic difference between due process and procedure established by law. So simply, under due process, you can question how. Right? How means you can question the law, you can question the intention of law. Suppose a law has been passed by the Parliament, right? So under due process, the question may be asked that whether the law is, or the intention of law is fair or just or not. But under procedure established by law, you cannot question the intention of law. You can simply check the provisions of law. Right? Just an example. For example, a law has been passed. Take an example of India. Right? A law has been passed by Indian Parliament. Right? That after 8 p.m. Right? After 8 p.m. no person is allowed to move outside of his or her home. Right? So what is it? It is what? Violating the person's liberty. Right or not? Article 21, Article 19, freedom of movement. So here, under due process, right, this law will be declared as null and void. But in Britain, suppose such law is passed, right, and such law is passed that no one is allowed to move outside of his or her home after 8 p.m. right, and anyone who moves out of his or her home after 8 p.m. right, he or she shall be arrested, right, and imprisoned for just an example 6 months. That is the punishment. Right? That time only the provisions of the law can be questioned. For example, person X, right? Person X moved out of his home just 7:30. So it is before 8 p.m. In spite of that, he was arrested. That you have violated the law. Right? That time the provision will be checked. That whether what is the provision of the law? The law says after 8 p.m. the person is not allowed to move outside of his home. But the time was 7:30. That time it can be declared null and void. Right? The person will be freed, not arrested. But as I said, under due process, it is violation of what? Liberty, freedom. So under due process, you can question the intention of the law itself. But under procedure established by law, only you can question the provisions of the law. Whether the provisions of the law is, or the implementation of the provisions is fair or just or not. That is the basic difference. And that's why the concept of due process is much more wider. It gives judiciary more power. So generally where there is parliamentary sovereignty, it adopts procedure established by law, and where there is generally constitutional supremacy or judicial supremacy, it adopts due process of law. That is the basic difference. Right? Now, types of due process. So, when we talk about types of due process, it is first is procedural due process. Second is substantive due process. Simple. So, what is the difference between both? Procedural due process and substantive due process. So, here procedure is checked, means the question is how. Right? We will see. For example, and under this certain notes are given. For example, if a person is arrested, right, that person should be conveyed the reason, right? For example, person X is being arrested by the police, then that person should be conveyed the reason by the police that why you are being arrested, right? There shall be no arbitrary arrest. Again, that person should be given right or the opportunity, right, or the representation, legal representation means that person can consult an advocate. That person should be given the opportunity to be heard, right? Substantive due process, mainly here certain substances or facts are checked, right? And here it focuses on what, that is the basic difference, right? So here you can see, here is the complete list. So as I said, procedural due process, it focuses on how a law is applied. As I said, focus is on how, right? And it ensures that the government follows established fair and impartial procedures before acting against an individual. And there are certain requirements. First is, as I said, notice. Notice what? For example, as I said, a person is being arrested, right? The person should be provided the notice that this is the reason that you are being arrested. Second, opportunity to be heard, obviously, legal representation, right? Third, an impartial tribunal or judiciary, whatever. And lastly, an orderly course of procedure, right? Free and fair trial of that person. The judiciary will decide whether the person is guilty or not the executive, right? Substantive due process, obviously, it focuses on the substance or content of the law. As I said, substance or fact or content of the law itself, ensuring that government actions do not violate fundamental rights. For example, right to life, right to privacy, right to marriage, right to property, right? So these are the two types of due process. First is procedural due process, second is substantive due process. Now, some other constitutions. So here, Eire or Ireland, right? In Irish language, Ireland is called Eire, right? So you can use both these terms interchangeably, right? So Ireland, Article 40, Clause 4, it says that no citizen shall be deprived of his personal liberty save in accordance with law. Simple. So means you cannot deprive a person from his personal liberty except what? Accordance with law. First, USSR, the constitution of Soviet or Soviet constitution, you can say. So here, Article 30, it says that no person shall be condemned and suffer any penalty, right? Penalty, punishment, right? Save in virtue of a judicial decision pronounced in conformity with the law. So here you can see that each and every constitution uses the word law, not the word state or executive. Only law. There should be proper law, and law should be just, fair, right, equitable, transparent. German constitution, West German constitution, right, 1948. So it says, Article 2, Clause 2 of West German constitution, it says that everyone shall have right to life, physical inviolability. The freedom of the individual shall be inviolable. Means you cannot violate the freedom of individual, right? And here these rights may be interfered only on the basis of legal order. So legal order means what? Same law. There should be proper legal order. And last, Japanese constitution. This is very important. Actually, it is identical to Article 21 of Indian Constitution, right? Though there is slight difference. So it says, Article 31 of Japanese Constitution, it says that no person shall be deprived of life or liberty, nor shall any other criminal penalty be imposed except according to procedure established by law. And same word is written in Article 21 of Indian Constitution, except this word, nor shall any other criminal penalty. So the basic difference between Article 31 of Japanese Constitution and Article 21 of Indian Constitution is that Indian Constitution Article 21 includes what? Only no person shall be deprived of his life or liberty except according to procedure established by law. But Japanese Constitution is more broader. It includes other type of penalties, other type of punishments also. Simple. That is the basic difference. So now be very specific, very clear that the actual origin of concept of procedure established by law is nothing but the Japanese Constitution under Article 31. Actually, and none other constitution uses the word procedure established by law. Actual phrase procedure established by law is written in Japanese Constitution under Article 31, and it is identical to Article 21 of Indian Constitution. Save this part of a statement, right? So the origin of the concept of procedure established by law is Japanese Constitution. Plus here also English positivism, right? English positivism here, it means we have also seen that, as I said, that procedure established by law is what? It gives more power to parliament and restricts the power of judiciary, because here you can question only the provisions of law, not the intention of the law. But under due process of law, what you can question the intention of law. That's why due process of law is more wider. Now we will discuss about in Indian context. So Article 21, obviously we have seen that it says no person shall be deprived of his life or personal liberty except according to procedure established by law. It does not uses the phrase due process of law, right? Now procedure established by law. So here you have to understand about these two words. Procedure. First, procedure means what? The law making process. Simple. And established by law means that is established by law of parliament, law of legislature. Simple. And you have to understand that the phrase procedure established by law, it simply means procedure prescribed by the legislature. Right? And procedure, already I have told you that it means simply the process of making law. Established by law means what? Established by the legislature of that state. And simply, and for this phrase you can also use this term, procedure prescribed by the legislature. That is the simple meaning of procedure established by law. So already we have seen, discussed, simply procedure means manner and forms of enforcing law. Established by law means what? By the use of these words, the Indian Constitution accepts the English principle of supremacy of law. As I said, that in any country, any state where there is parliamentary sovereignty, it adopts the concept of procedure established by law, not due process of law, right? But in India, we don't have parliamentary sovereignty, we have parliamentary supremacy. See, generally aspirants have confusion and they use both these terms interchangeably, parliamentary sovereignty and parliamentary supremacy. But there is slight difference between both. And I have made a separate video of 10 to 15 minutes video. You can watch that video. Link is given in the description box, right? So in simple terms, I want to tell you that parliamentary sovereignty means parliament has unlimited, unrestricted, unfettered powers. But parliamentary supremacy means where there is written constitution to limit the or check the power of parliament. In India, we have parliamentary supremacy. In Britain, it is parliamentary sovereignty. Clear? So, by adopting this concept of procedure established by law, India preferred the concept of or the principle of supremacy of law over the doctrine of or American doctrine of judicial review of legislation so far as personal liberty is concerned. And liberty already, it means what? According to the above view, this view, right? is a liberty confined and controlled by law. Obviously, in India, we don't have absolute rights, right? Means there are reasonable restrictions even on fundamental rights, right? For example, Article 19, Clause 2 talks about reasonable restrictions, right? Public order, peace, health. So there are certain reasonable restrictions. Quite clear? Means liberty can be confined and controlled by law, even in India. Law already I have discussed, no need to discuss. So procedure established by law thus means procedure prescribed by the legislature. Already I have told you. Simple. Now, certain. Now, question arises: why our constitutional fathers, the members of Constituent Assembly, right? They adopted the concept of procedure established by law over over due process of law. What was the reason? See, the constitutional expert B.N. Rao, right? He traveled to US, America, right? And there he met Justice Felix Frankfurter, right? Who was the Justice of Supreme Court of America that time, right? And Justice Frankfurter advised to B.N. Rao that due process of law clause is undemocratic and burdensome on judiciary, right? And he followed his advice. Means B.N. Rao followed the advice of Justice Felix Frankfurter, who was the Justice of Supreme Court of America, right? And there were certain other members, right? For example, K.M. Munshi, he favored due process of law, right? But another member like Alladi Krishna Swamy Iyer, right? He was against the concept of due process. So, what was the conclusion? Lastly, B.R. Ambedkar, Dr. B.R. Ambedkar, right? He summed up the two views. Means some favored the due process and some were against the due process. So, Ambedkar merely summed up this idea and left it to the Constituent Assembly, that take it in whatever way you like. And finally, the House, means the Constituent Assembly, adopted the clause procedure established by law over due process of law. Means the concept of due process of law was rejected by the Constituent Assembly and procedure established by law was adopted. Right? This is the story behind the adoption of, or the logic behind the adoption of procedure established by law under Article 21 in India. Right? Now, how the concept of due process of law evolved in India. So, first important case is, you must be knowing, A.K. Gopalan case, right? A.K. Gopalan case versus A.K. Gopalan versus State of Madras, 1950. So what happened? That A.K. Gopalan was a communist leader, and he was arrested in 1947, detained, right? And even after independence, his detention was continued under Preventive Detention Act 1950, right? Under Section 3, Clause 1, right? His detention was continued. And that's why he challenged, right? Or he filed a writ petition in the Supreme Court of India under Article 32, right? And you must be knowing that if your fundamental rights are violated, then you can file a writ petition in the Supreme Court or under Article 32 or under Article 226 in the High Courts. So he filed a writ petition in the Supreme Court under Article 32. Quite clear? So the Supreme Court held that the Constituent Assembly deliberately adopted the doctrine of procedure established by law and being under the interpretation of Article 21 was outside the purview of the court. So here the judiciary took a narrow approach. Narrow approach means it went with the Constituent Assembly, and Constituent Assembly had dropped the idea of due process of law, and the reason I have already discussed, right? So in this A.K. Gopalan case, the judiciary, means the Supreme Court of India, adopted a narrow approach. But one judge, Justice Fazl Ali, right? You have to remember the name, very important. Justice Fazl Ali, he dissented, he disagreed, and he said that no, Article 21 should be interpreted more liberally. Though we have means though Constituent Assembly has dropped the idea of due process of law, in spite of that, we should have liberal interpretation of Article 21. And he mentioned that Article 21 should be read with Article 19, right, as they are interrelated to each other. And procedure established by law in Article 21 is not synonymous with due process of law. It was the judgment of Supreme Court. But Justice Fazl Ali said that no, we should adopt a liberal interpretation of Article 21. But Supreme Court finally said that no, procedure established by law in Article 21 is not synonymous to due process of law. Simple. So it was a narrow approach of Supreme Court. But another important case, R.C. Cooper case, right? So here the Supreme Court observed that the fundamental rights guaranteed by the Constitution are not mutually exclusive to each other. Here it opened its eyes, right? Had a broader approach, and they somehow tried to correct their mistakes of A.K. Gopalan case, right? And R.C. Cooper case, Supreme Court said that no, there is no exclusion of certain fundamental rights. Means fundamental rights are mutually interrelated, right? So the court cited that law means a law which is within the competence of the legislature and does not impair the guarantee of rights in part 3. So here it restricted the powers of legislature, means parliament, that it does not or it cannot impair the guarantee of rights in part 3. Means simply fundamental rights cannot be violated, right? And this gave wider interpretation of Article 21 as law inconsistent with the fundamental rights can now be declared void. So simply the mistakes that was done in A.K. Gopalan case was corrected in R.C. Cooper case. Here it was a narrow approach, but here it was a broader approach, more liberal interpretation of Article 21. And it simply held that but any law that is inconsistent with the fundamental rights shall be declared void, right, invalid. Now another important case, very famous case, Maneka Gandhi case. So again you must be knowing about the story, right, that her passport, right, the passport of Maneka Gandhi was impounded under Passport Act 1967, right. She was going to travel abroad, but what happened that her passport was seized, right, and that's why she challenged this action of executive in the Supreme Court, right. And the landmark doctrine, it said that procedure under Article 21 must be right, just, fair and reasonable, right. And here, though not in words but in spirit, the concept of due process of law was adopted by the judiciary. That though due process of law is not mentioned in Article 21, in spite of that, it is in spirit in Article 21, right. So, and again the Supreme Court gave an important concept that is known as golden triangle. Golden triangle means what? Article 14, 19 and 21 are interlinked, right. Means Article 14, 19 and 21 are known as golden triangle, right. None of these can be separated. Right to equality, right to freedom, right to life, right. And in Maneka Gandhi case, the Supreme Court adopted much more wider approach, right, than R.C. Cooper case. And finally, effectively imported procedural due process. Obviously, we have discussed the meaning of procedural due process. Means you can check the intention, why, how, right. Natural justice, notice, hearing, reasoned order. Simple. And opened the gates for substantive due process, law's reasonableness. And lastly, from this moment, procedure established by law text remained, but due process of law entered through judicial interpretation. So Currently in India, the phrase due process of law remains in words, right? But the phrase, right, sorry, the phrase procedure established by law remains in words in Article 21, but the concept of due process of law or the phrase of due process of law remains in spirit, right, in Article 21. Simple. So, if question arises that whether Article 21 includes due process of law, your answer should be yes. What is the proof? R.C. Cooper case, Minka Gandhi case. And Minka Gandhi case gave much more wider interpretation. And again, it introduced another important concept of golden triangle. Article 14, 19, 21, right, are interlinked to each other. Simple. Next, again, recent judgment, K.S. Puttaswamy case. Obviously, it is related to right to privacy. Again, right to privacy is part of right to life. So, here, right to privacy declared intrinsic to Article 21 means right to privacy cannot be separated from right to life. Right? Any restriction must satisfy proportionality test, legitimate aim, rational nexus, necessity, balancing, and full substantive due process. Right? And lastly, this in short it is called INSAF versus Union of India 2020. So in this case, it held that legislative objective must align with the fairness while interpreting or executing laws. Simple. And today, India follows procedure established by law textually, but due process of law in spirit. Already I have explained, right? So if question comes in prelims that Article 21 consists procedure established by law, due process of law, none, both. Your answer should be both. Why? Procedure established by law textually, due process of law in spirit. Clear? Now finally, just have a quick look between the differences, right? So here, due process of law, as I said, what? US 5th and 14th Amendment. Why? We cannot written or we cannot write England? Because England dropped the idea later and moved towards the concept of procedure established by law. Right? Though actually originated in England, but it was dropped by England and what remains only in the US Constitution. Simple. Procedure established by law. So here already we have seen which article of Japanese Constitution? Article 31. Right? Though more wider than Article 21 of Indian Constitution, but actually Article 31 is identical to Article 21 of Indian Constitution. And again, English positivism, obviously, right? Because in England there is parliamentary sovereignty. Next, types, obviously procedural and substantive, but procedure established by law is just procedural. Here you focuses on the procedure, the provisions of the law, right? Next, judicial review of law, obviously we have said, right, that due process of law is very wide, right? And it gives judiciary, you can say, the wider or the opportunity to or opportunity for wider interpretation. Procedure established by law very limited, and mostly here judiciary is weaker. Where there is parliamentary sovereignty, there generally there is weak judiciary. For example, in England there is weak judiciary, but in USA, in India, there is very strong judiciary. Or you can say that where there is constitutional supremacy, there is judicial supremacy. Why? Because only the judges interpret the constitution. In that sense, there is judicial supremacy, whether it is USA or India. And if you compare with the between the Supreme Court of USA and India, you will find that the Supreme Court of India is more powerful than American Supreme Court. Right? Fundamental rights approach, obviously it safeguards citizens' rights from both executive and legislative actions. Why? As I said, we have seen that it is more wider. Here it limits the power of judiciary to evaluate the procedure used by the legislature to enact the law in question. And lastly, protection level broad, obviously, and Here, procedure established by law, it is very narrow. Now, certain similarities. See, similarities, the intention of both, whether it is due process of law or procedure established by law, is what? To protect individuals' rights, whether it is due process of law or procedure established by law. Their main intention is to protect the individuals rights, to protect their life liberty, right? Again, it also checks the what, the arbitrary action of legislature. Simple. So these are the few similarities, but mainly you have to focus between the differences of due process of law and procedure established by law. So in this video lecture, we have touched each and every aspect of due process of law and procedure established by law. I hope this video is helpful for you. Thank you.